Section 2 talks about the jurisdiction the court has over cases. And if just to distill it, any case regarding a federal statute or a federal law can go into federal court and ultimately can wind up at the Supreme Court. Cases, there are only two sets of cases that can wind up as original jurisdiction that start and finish at the Supreme Court. And those are cases that involve ambassadors and public ministers and consuls, and also when states are a party to, states suing a state. So North Carolina versus Georgia, whatever. Georgia and I believe Florida had a number of times where they wound up at the Supreme Court because they're arguing over the boundary. And the case was filed in and started and ended at the Supreme Court. Those are the only ones that start there. But the other bit of jurisdiction for federal courts was about judicial review. And this was the famous case of Marbury versus Madison back in 1803, which ultimately the case said, look, it doesn't say so necessarily in Article 3 in Section 2 that this is part of our jurisdiction, but we're going to consider this an implied power. And that is, we can review actions of the executive branch and the legislative branch to say if they're constitutional or not. And that has been the law since 1803.
Right. And a lot of it comes down to what's known as a federal question issue, where if there's a question regarding a federal question that has to do not with just a federal statute, but the interpretation of the U.S. Constitution, then that's something that the Supreme Court can take up. And where you'll see is that, if it's something involving the federal, again, one of the federal branches, the executive branch, or even with Congress or something like that, of course, that's going to come up. That's something that the Supreme Court has jurisdiction over as part of that federal question. But then what you'll see is most often you'll have cases that come up, work their ways up through state courts, and then get appealed to the U.S. Supreme Court, not based upon the interpretation of a state law, but by the claim that there's a federal question that directly affects a person's U.S. constitutional rights. I mean, during my career, I actually had two cases that were actually appealed up to the U.S. Supreme Court. Both were denied cert, but for various reasons. But what the question was, it was as a criminal prosecution. They were saying that and they went all the way where they worked their ways all the way up through the state Supreme Court, the Connecticut Supreme Court, and the Connecticut Supreme Court issued a decision. And then they appealed it to the U.S. Supreme Court saying, yes, although that this is something that the state court decided on a state constitutional issue, we are saying that there is a greater federal constitutional issue that's being affected here, that we're asking the U.S. Supreme Court to take a look to see if the way that the state Supreme Court interpreted this state law, that we're saying that this state law and the way that it was interpreted violates one of my federal constitutional rights. So that's a way that it can work its way up through, actually, because a lot of people are like, well, that's a state case. How can that get appealed up to the U.S. Supreme Court? Or, I'm going to appeal this all the way up to the U.S. Supreme Court. Well, good luck, buddy. You got to wind your way all the way through the state courts and then pray to God that you hit a Hail Mary blindfolded in hurricane winds with the lights off.
Right.